We have Helena Nelson, the supervisor of the Water Resource Division's Enforcement Unit, and she's going to talk about addressing violations of Michigan's wetlands, lakes, and streams law. So happy to turn it over to you, Helena.
Okay, thanks, Todd. Let me just share my screen. Okay, do you see my first slide?
Yep, I think you're good.
Okay, yeah, so like Todd said, I'm Helena Nelson. I supervise the Resources Enforcement Unit in the Water Resources Division at EGLE. I've worked for the state, for EGLE for 10 years. Started out doing permitting and compliance in wetlands, the wetlands program in the Jackson office. And then I spent 4 years up in Marquette. And then I transferred down to Lansing to be the litigation specialist for the unit. And I've had this current role since January of this year. So yeah, we wanted just to kind of set the stage here. We've been making a lot of changes to our compliance and enforcement program in the resource program over the last year and a half. And so those of you who interact with field staff may notice there's some differences in how we are handling compliance versus permitting in the field. So, you know, part of that is an effort to essentially level the playing field so that we're not holding permit applicants and those who are abiding by the law to a higher standard than those who do not follow the law. So I'm pretty excited about the changes, and we've been growing our unit, and so I'll get into that a little bit in a little bit. So just as an overview of what I'm going to talk about today, generally, kind of what do I mean when I'm talking about violations? How does one report a violation to the WRD? How to respond to a violation notice, and then a little bit about our escalated enforcement process. And I'm going to focus today on part 303 and 301, just since this is a wetland presentation. So part 303, the wetlands protection, when I'm talking about violations, we're talking about any of the activities that are prohibited without a permit that are laid out in the statute. So if somebody places fill or dredges a wetland, maintains a use or development, drains surface water from a wetland, those are if they do those things without a permit, you know, and it doesn't meet certain exemption requirements, then that is considered a violation of 303. And then also part 301, inland lakes and streams. Similarly, you know, the activities that are prohibited without a permit include dredging and filling bottomland, placing structures, enlarging inland lakes and streams, interfering with the natural flow of those waterways, in any of the listed activities that require a permit under 301. So I'm focusing on those for this presentation, but we do compliance and enforcement in other parts of the NREPA, so dam safety, the Critical Dunes Act, shorelands protection and management. You know, there's floodplain regulations, Part 91, soil erosion. So oftentimes, you know, a case will involve multiple statutes, and each statute has different provisions that speak to what exactly is regulated and what EGLE's obligations and enforcement options are under those specific statutes. But I'm going to focus primarily on 303 and 301 today, but really the process is essentially the same for all of those. So this is a very basic flow chart of kind of what I'm going to talk about. So we're starting to begin with, I'm going to talk about, when we first get a complaint and how that happens, and how that can be done if, say you're in the field and you come across something that you think is a violation, or, you become aware of a suspected violation, how to report that to EGLE. That we also do ourselves come across violations in the field. And so that's kind of another potential starting point for the process. So one way so if you do want to report a suspected violation, you can go to our MindViro portal, and on the screen you see what that looks like when you go to that page. And there is a button for submitting a complaint of pollution spills or unauthorized activities. And then when you click that, there's two options. The first one is related to spills and pollution. And the second one is what you would click for, your filling, dredging, placing the structure, etc., in the wetland or lake or stream. So once you click that, then it takes you to this form, and you'll click to begin the form, and it asks for really just some basic information. So a description of what the violation is, whether it's a one-time or ongoing issue, the dates, and and really for like the date, if you may not know the exact date that the activity occurred, so kind of your best, if it's just the date that you observed it, that's fine. And I think, putting any information in the description that will really be useful for us in prioritizing, and I think some of the other information that might be useful to compliance staff is like, is this something that is visible from the road or a publicly accessible area, so that we have a good sense of how we can plan to go about going out to confirm a violation or to verify. So it then asks for information about the property owner and or the contractor. These fields are optional, but if you do know the information, it would be it's very helpful if you can enter it, so that when we do have to reach out, if and when we do have to reach out, we have that information as well. There's also, you'll be prompted to enter a location for where the violation was observed. And there's a little Google map that you actually will click to drop a pin, and that's important so that we have the accurate location information. So you can enter the site address too if there is an address, but putting that pin in the correct location is very important for us. And then it asks for you as the complainant and your contact information. You can opt to be kept confidential, and that means that if we get a FOIA request or anything like that, we would redact your contact information. It is beneficial if we have your contact information, so that if we do have questions or want any follow-up information, we can reach out to you. So if you're able to provide your phone number, email address, that is great, but you don't have to. And then there's an opportunity to attach files. So if you have photos of the activity, that's really helpful for us. So we can get a sense of kind of what's going on out there. But yeah, and then it asks for the size and scope of the incident. So, you know, just again, like your best estimate of what the size of the violation is, that will help us to prioritize our inspection and follow-up action. And then there's just an opportunity to review your information, and then you'll submit it, and you'll see in the top left hand of the corner, or top left corner of the screen, there's a submission number that will appear. I think you get an email too with this once you get this submitted. But if you have that submission number, I would write it down so that if you do want to reach out or have questions, want to have a follow-up conversation with EGLE staff, you can reference that, and it makes it easier for us to figure out what you're talking about. So this gets into the changes that I was talking about at the beginning, that up until about a year ago, a year and a half, I'm not sure actually when this change officially happened, but you know, up until recently, we've basically, those of you who are familiar with the permitting process know that we had staff in each of the district offices who previously would cover a specific county or counties or a portion of a county, and within their area would do both permitting and compliance duties. And we didn't have specific dedicated compliance positions in the resource program, meaning like the Wetlands, Lakes, Streams program. So what we've now got a compliance position, compliance coordinator in each district office, and so their position is a compliance position. So they are your point of contact if you have questions or want to discuss a suspected violation. You can see there's a staff map that's actually on our website now that shows who in each district office is covering that district for compliance. And you'll see that right now Jackson and Lansing are vacant because Jeff Pierce was in that position, and he has since taken the district supervisor position for those districts. So that position will be filled soon, hopefully. But yeah, so these positions are going to be, well, are currently triaging the complaints that come in, following up on most of the complaints, and really handling the compliance in the district, you know, coordinating with other district staff as necessary in their office for the follow-up response, but really are coordinating the compliance efforts there. And they're also inspecting permitted projects. So, you know, they're actually, you know, planning out and conducting inspections regularly on a number of permits that have been issued for their area to determine if they are in compliance with their permits. And again, that just goes to that, you know, leveling of the playing field. There's, you know, I think a lot of entities out there who follow all of the rules and the laws and do everything that they're required to do. And, you know, that can take considerable effort and time and money. And, you know, there's this level of unfairness for those who don't follow their permit conditions and their rules. And if they're not, you know, held accountable for that, that really creates this non-level playing field. So yeah, and then, you know, there's certain instances where these compliance positions will refer a case for escalated enforcement or to our resources enforcement unit, so my unit, and then we'll work with these staff to on that escalated enforcement action if that's warranted. So I'm going to talk a little bit about our violation notices next. So, you know, we kind of went from, we've received a complaint, and then those staff that I was just referencing, those compliance staff usually will be the first ones on the ground, or it might be permitting staff in some instances, but they will follow up and conduct an inspection, and if a violation is confirmed, then they will issue a violation notice. And I will just also want to note that you know, if staff go out in the field and observe a violation, maybe had no idea that they were going to encounter that day, or they don't have contact information, aren't able to find contact information for the owner, we might post one of these notices on the property. And it basically, this is an old one, as you can see of mine, but it asks, you know, it advises that there's an apparent violation on the property, and then includes contact information requesting that whomever the property owner or agent is reach out to that person to discuss next steps and discuss the apparent violation. So I just included this reference from 303 that specifically says that if the department finds a violation, that it shall issue an order requiring that person to comply with the prohibitions or conditions, or the department shall request the Attorney General bring a civil action. And we, in our program, in the resource program, there's 3 primary types of violation notices. Typically, the first notice that will get sent once field staff have gone out and confirmed that there is in fact a violation, we'll issue an information request. And then based on that, there's potential options from there. Another type of violation notice is an after the fact. And then we've also got an order to restore. And then there's also sometimes, depending on the circumstances, there might be a second violation notice of any of those types. And there might be sometimes the violation notice might be a combination of these types of notices. So I'm just going to kind of talk generally about these different types. So this is a request for information. So again, that initial letter that goes out, collecting information so that we can determine how to proceed. And I just want to kind of touch on some of the components of the letter. So there is a violation notice number in the upper right hand corner. So if you're calling to discuss a certain a letter that was received, that can be helpful if you're communicating with the staff person, so that they can look it up in our database to know what specifically you're referencing. And then we have a paragraph that talks about, you know, a description of what was observed, what the violation is, what you know, was it filling in a wetland? Did they you know, put shore protection along a stream? Like it will describe what the facts are and what the actual violation is, and include a citation in the statute for what specific provision was violated or provisions. And then there should be a deadline to respond. So that's important to note. you know, if for some reason, you aren't able to meet the deadline or your client isn't, it's important to reach out and stay in communication with us, but we really do need a response by the deadlines that we provide. Otherwise, we're gonna have to keep things moving. So this information request, there's a list of information that will be requested. We kind of have some standard information that's usually requested, like the date that the work was undertaken, names of the property owners, the contractors, what the purpose of the project was, whether there's any wetland delineations on the property, and there might be other specific information that we request based on the specific situation that we're dealing with. Because basically we're trying to collect the information that we need in order to make a determination on how to proceed. Usually it says, like you can see here, number 7 says any other relevant information that will assist our review. And really, so if there's anything, that you think is important information for us to consider, even if it's not something specifically listed, it's really helpful for us to have as much information as we can, so that we can have the most meaningful conversation that we're able to and discuss, how to bring the property into compliance, what the appropriate recourse is. So like, if there's photos or anything else that you think is relevant, really that should all be provided with the response. And then there is contact information for who, which compliance staff is assigned to this case. It'll have their phone number and email address so that you can reach out directly to the correct person, without being bounced around, to a bunch of different staff. So moving on to our after the fact violation notice. So if we determine based on the information that we've gathered that the project could have been permitted, and typically these are, like things that meet a Maya project or a general permit category, or projects that had the activity been applied for to begin with, and we would have permitted it, then we can we can issue this after the fact notice. And that the statute part 303 and 301 do say that if we are going to process an after the fact permit application, that the application fee is twice the normal fee. And the after the fact letter will include a deadline for submitting an application through the MyEnviro portal. So it is important to keep an eye on, make sure that you're meeting those deadlines, because if we just don't hear anything or receive the application, we don't know if the plan is to actually submit an application or not. So and then the other type is the order to restore. And so this will be if we make a determination that the project could not have been permitted, or if a portion of the project can't be permitted, then we can issue this order to restore. And sometimes the order will actually ask for a restoration plan, depending on how complex the restoration needs to be. Or we might just specify what the actual activities are that need to be completed in order for the site to be considered restored. We might have a map like you see here that depicts the specific area that we're identifying as the area needing to be restored, or any other components, specific actions and where they need to occur. Depending on kind of every situation is a little bit different, but this will depend on kind of the complexity of the situation and what's warranted in that scenario. And there might be questions. I think this one is one where it might be some questions about what exactly we're looking for. So again, like the contact information for the compliance staff person will be in the letter that's issued. So that can all, you can always reach out to that staff person and have a conversation if you've got questions or want to discuss it. Some of the things that we are looking for if we request a restoration plan, and this is again every situation is going to be specific to what the actual project is, but in general, we need a timeline for when the restoration is going to be completed. Site plan and cross-section drawings are typically helpful so that we know where on the property the work is going to occur. Having grading plans showing the existing and proposed elevations, planting plans, so that with a plan for what if planting is warranted, what those species are going to be, when they're going to be planted, that kind of information. If spoils need to be removed, where they're going to be located, where you're going to place them, how you're going to make sure that erosion's not the earthwork is not causing active erosion into waters of the state, anything like that. Those are kind of some of the basic components, but again, there might be additional things or some of these might not apply. And we are starting to more often create schedules of compliance for these situations. So I'm going to get into that a little bit later. But this is just kind of some rough data for the violation notices that we issue statewide over the last 3 years. And some of this might be, so I pulled this from our MyEnviro portal, and I do think while we're also ramping up our compliance efforts by having dedicated compliance coordinators in each district, we're also, I think, we're making improvements to our process in our database in MyEnviro. So I do think we have better data now too. So this is just based on what's in there. So yeah, you can just see some of the numbers. So ideally, if we issue a violation notice, we gain voluntary compliance, and that's, if restoration was required, we'll send a restoration completed letter, or if we ask for an after the fact permit, a permit's issued, and we just have voluntary compliance at that point. If that's not where things go, then we'll end up in the escalated enforcement realm, and that's where and there's still there's some different types of escalated enforcement that can include an administrative consent agreement, which again is really a form of voluntary compliance, or we have civil and criminal remedies available under the statutes that we administer. So I just wanted to kind of try to put into context where the resource enforcement unit lies within WRD. So this is kind of the overview of this is our org chart that's available online. So you can see we have the field operations section is what are all the district staff that, the permitting staff and the compliance staff in the district offices. And then in the field operations support section, that's where the resources enforcement unit is housed, as well as, our wetlands, lakes and streams unit, transportation review unit, dam safety unit, which you might be a little more familiar with. So the resources enforcement unit currently is made up of these individuals. So another change that we've made in the last year or so is that we have additional resource enforcement unit staff. We've created 3 new positions in the last less than a year. So previously, you may or may not have worked with Justin Smith, Jeff Fisher, or Christy Wilson. They're kind of our field enforcement staff. So they're located, Christy Wilson's located in Marquette, Jeff Fisher's in Grand Rapids, and Justin Smith works out of Lansing. We have 2 new field positions. So Brendan Mitchell will be covering the northern lower, so Gaylord and Cadillac districts, and then Matt Angelo Santo covers the southeast, Jackson and Warren districts. So they're pretty new and learning quickly, so we're excited to have them on board. And then we also have Danielle McLean as our litigation specialist. And then we have Nathan Dollar, who does some litigation and also works on contested cases. So Chris Kahn also is in our unit and works solely on contested cases. So and then we have a vacant position right now, so that should be posted any day now if you're interested. So if a case does get referred to our unit, and if we are at a point where escalated enforcement is appropriate, our first step is typically to issue what's called an enforcement notice, and that there's different scenarios in which an enforcement notice will be issued. Oftentimes, the enforcement notice is going to offer to resolve the matter through entry into an administrative consent agreement. So there's various scenarios in which this might be the point at which we get to. It could be that the violation is particularly large or complex or particularly egregious, or if compliance staff have attempted and have been unable to obtain voluntary compliance, then we start looking into requiring, or the next step is typically trying to get a voluntary consent agreement entered. And those, again, this will offer, it'll have contact information for the staff person assigned, the enforcement unit staff person, and then it'll ask for a response and offer to meet to discuss the contents of the enforcement notice. So if we do get into discussing negotiating an administrative consent agreement, that's a legally binding document that gets entered voluntarily by the responsible party and EGLE to resolve the violations. They can vary on specifically what's included, but kind of our typical components are that there would be, if restoration is required, it'll have a compliance program and an implementation schedule that lays out deadlines for completing certain activities, or it may again ask for a restoration plan to be submitted for EGLE approval. And then there's typically a monetary penalty once we're at this stage. And there's stipulated penalties laid out in the agreement. So basically that will say that if any provision of the agreement is violated, then there's penalties that are imposed. If we are requiring restoration or mitigation, there's typically monitoring requirements. Usually 5 years of monitoring or 10 for forested, kind of similar to mitigation for permit mitigation. So there'll be provisions for monitoring. There's an exhibit that usually lays out what to include in the monitoring reports and what the performance standards are to successfully complete the restoration. But again, these can all vary pretty widely, but just generally speaking, if we do, issue an enforcement notice and the responsible party is interested in entering into a voluntary agreement, then we will draft one up and send it to the other party for review. And then we get into some negotiation. We'll probably have at least a settlement meeting, if not more, to discuss the terms of the agreement, and make sure that we all agree on them. And then it doesn't get fully executed until it's signed by the responsible party, the assistant attorney general and an assistant attorney general and the WRD director. And then most of our administrative consent agreements will have schedules of compliance like I referred to earlier. And this just shows kind of what that looks like as an external viewer. So if you are associated with a site that has schedules of compliance on it, you'll see it allows you as an authorized user to submit directly to MyEnviro. So that might be submitting notice to us that the restoration is complete, or that you can submit the conservation easement documents or submit the annual monitoring reports. And so there's we can authorize users. So if you're, say, you're hired as a consultant on a restoration or a consent agreement restoration or mitigation project, we can authorize you as an editor for the site, and you'll get an email that once you click that, it'll link you to that site, and then you can actually make these submissions, and it will show you like the due date for each of the schedules. This is just an example of what I was talking about with the monitoring requirements in an agreement. So it'll spell out specifically what we're looking for in a report. And so it's really important, if you are doing monitoring for an agreement, that you have a copy of the agreement itself and can look at this exhibit that specifies what it is that is required to be submitted annually. And usually that includes, permanent photo stations. There's usually transects that are identified in the initial plan, that where there's monitoring plots that, and then throughout the monitoring period, if you identify any problems, if it's not developing as a wetland, or not, if it's not going to meet performance standards, the report should include measures for how you plan to address and correct the issues. So if we aren't able this, I don't have a lot on our additional remedies, but if we are not able to resolve a matter administratively, EGLE will refer the matter to the Department of Attorney General, and an assistant attorney general will get assigned. And we might continue to negotiate depending on kind of the status of our negotiations. There might be the assistant attorney general who's assigned may reach out and engage in additional negotiations. And if that is still unsuccessful, then we'll file a complaint in the circuit court. And depending on what the counts are, what specific statutes were violated, there's different maximum civil fines. I've got under 303, it's $10,000 per day of violation. Under 301, $5,000 per day of violation. So obviously that can add up very quickly. So we can still, if we get into that point where we filed a complaint, we can still, if we do end up coming to a settlement agreement, then that would be entered as a consent judgment that's filed with the court or entered with the court. And there's also provisions in both of these statutes for criminal that you know, these are violations can be a misdemeanor, and you know, kind of what the potential remedy is for those. I'm not planning to talk about that a lot. This is just again recapping kind of some of our escalated enforcement numbers for the last fiscal year. So we have been pretty busy. We've got, you know, we issued 16 enforcement notices, entered 11 administrative consent agreements. We referred 10 cases over to the Department of Attorney General and initiated 7 lawsuits. So we also have about 20 to 24 ongoing active litigation cases in various stages. So we definitely have a lot going on in our unit. So yeah, I think that's all I have. This actually is a picture of me from when I worked in Marquette as a field staff and was documenting a violation up in the UP and standing next to a giant spoils pile. So yeah, if anyone has questions, we can open it up.
I answered a few sort of specific questions in the chat, but I can I saved a few more general ones for the Q&A. But Todd, do you have anything you want to add before we do that?
No, I'm listening. I just wanted people to see me.
Awesome. Okay, so this question I'm going to try to answer, and then I want Todd to answer it, and then we'll see if Helena has anything left to say about it. So the first one, this was an anonymous question. When completing a wetland delineation and it is noticed a violation has occurred under Part 303, is it the complaint process we take to report it, or there be a different process? So my answer to that is you can use the complaint process. You can fill out a complaint. I'd like to think that if you have, like, if it's on the property that you're working for the client, then I'd like to think if you have a good enough relationship with that person, you should be talking to them about their violation, and you should be contacting the department as quickly as you can to try to resolve that if there's like a development project or something coming, because if you wait a long time and you're thinking you need a permit and then it comes out during the application process, that can be an issue and it can really slow things down. Todd, as a consultant, what's your answer to that?
Yeah, no, I think the first, which is, yeah, you could use the online process to report it. But you're right, if you're working for the client, you're gonna have to try to resolve it if it's on the same property. So I don't think I have much different advice on that.
Oh, good. Helena, do you have anything to add on that?
No, I don't think so. I think you answered it well.
Okay, good. Okay, Helena, this one is also from is also anonymous. I submitted a complaint and requested that my identity be kept confidential. Will I be notified as to the result of my complaint and any action taken on it?
No, the short answer is no. So if you want to know what the status is, you really should reach out to the compliance person in that office and ask.
Thanks, Helena. So Valerie was asking about what are the changes that have occurred over the past 18 months to level the playing field. And I think that was the part of the presentation that you were talking about, all the additional staffing that we've added. So I don't know if you want to talk a little bit. How many positions is it altogether?
Yeah, so how many, I want to say 9. How many district offices do we have?
Yeah, I don't know.
So
I'm thinking it's 10.
10.
But we can add that up. So that's really, I think, what we're talking about. We have made some process improvements, and like Helena was talking about, we're trying to improve tracking of complaints and enforcement actions. So there's other things, but it's not like I don't think we've like totally changed the way we do compliance and enforcement. We've just added resources to it.
Right. I mean, yeah, I almost had a slide that showed we used to have 0 dedicated compliance staff in the district offices, and now we have 10 or 9 or whatever it is. And so I think that makes a big difference when you have just having worked in the district offices doing permitting and compliance. It's very difficult to juggle those, and to be able to have a staff person who's solely dedicated to compliance is, I think, pretty huge for our program. And being able to like triage all the complaints that come in and prioritize them and follow up on them. And then, you know, staffing up our enforcement unit. Because too, that the compliance staff are gonna be doing, you know, inspecting permitted projects and are just out more. I anticipate that we're going to be finding more violations than what we have been, and actually following up more on violations than we had been. That's kind of what we expect, I guess.
So I counted, so it's 10.5 if you count the new folks in your unit too. So
Okay.
okay, thank you, Helena. Okay, how do you determine fines? I know that's not an easy answer, but if you could give a general answer, that'd be great.
Yeah, I guess, well, I guess I shouldn't assume that. I mean, so if we're in negotiating an administrative consent agreement, we actually have a penalty matrix for based on what depending on which statute the agreement is under. And so that will depend on like where the initial penalty starts is based on the severity, the magnitude of the violation, and the degree of impact to the environment. And so if, you know, we take into account the magnitude and the impact of the violation, and then we also take into account a number of other factors. There can be, and often is, a multi-day penalty that gets added to that. And so it does get very complicated. I mean, every situation is really different again, but we also will consider, you know, whether the responsible person is a repeat offender, whether they are being cooperative, what like the value of the resources, the restoration potential of the resource. There's a number of factors that we consider that go into our calculation of the penalty. Yeah, I guess that's kind of my short answer.
Great.
Is there anything you want to add to that?
Another question, is the Army Corps involved at any stage?
Yeah, so if the activity is in a section 10 water, then we would coordinate with the Army Corps on the response. That
Yeah, I'm reading the next
do
question.
you have anything to
Sure.
add? I don't.
Those are in totally separate processes. So you both could go after them, or you could choose which agency is going to be the lead, right?
It does get, I mean, it gets a little complicated. We try to work as best we can with the Corps. Their process is different because usually they will require a permit for And I don't want to speak for the Corps because obviously I don't work for the Corps, but from my experience, they'll typically require a permit for the activity, whereas we might be just ordering restoration. So even the restoration, they'll require a permit for, whereas for us, on our side, we don't. So that gets a little tricky because we're not trying to process an application for that. So we have to communicate with the Corps person for that area on kind of how that's all gonna play out.
Okay. So Helena, someone's asking about, and I'm gonna translate this a little bit, but they're saying when we were doing triaging of violations, what sort of response would EGLE have to an impact if it differs slightly because, between the design and construction? So they're talking about permit compliance, but I'm wondering if maybe you should give more of a broad answer on talk a little bit about that we triage things by severity, kind of, if you could talk about that for a minute, that'd be great.
Yeah, I mean, it's obviously going to depend on what what the priorities are in the district. Programmatic priorities, but each district staff person might have a different workload, and they're going to prioritize based on, obviously the severity. If there's something that's ongoing, that's actively happening, that's obviously going to bump it up the priority. Size, magnitude, impacts to high quality resources, that kind of thing, again, is going to bump it up in the priority. But
I think that's good.
What we can't, it gets tricky because it's not like we have hard and fast, here's what's allowable and what's not, what we can, it's hard to kind of set guide rails on exactly what the priorities are, but in general, it's going to be based on the size and severity and what the impact is, whether kind of the same factors that go into what the penalty is that I talked about.
Okay. So there is a question about the recent Supreme Court decision on the Clean Water Act, and I'll take that one for you, Helena. So our assumed 404 program is administered under state law. And so all of the changes over the last decade at the federal level, there's been court cases and many different rule changes and all that. We've been pretty buffered from that because we do run our program under state law. And so nothing is really changed due to the Supreme Court's recent ruling. I think that might be it on the questions. We'll wait here for 1 second while I double check, and then I think that's it. Thank you, Helena.
Yeah, I wish that person had a name because that's right. I like that haircut. So thank you for that peek behind the curtains there, Helena. I think it was pretty interesting. We had over 150 people logged on, so very good. Join us next time on October 26th for the Marsh Bird webinar. And thanks again, Helena, and thanks everybody for coming to the webinar.